Okay, hit record. Officially welcome to this week's Ask Me Anything. How can I help you guys? I'm going to open chat as well. Let's see. Anybody else that joins in? Am I muted? I think I am not muted. Should be good. All right, welcome. Wayne, are you there? Kathleen, are you there? Can you hear me? I see a couple videos, but you're welcome to unmute if you've got a question. I'm going to also open chat, so if we have anybody else that pops in, if they have a question, they can type it in chat as well. We had to bump today because I had a mastermind call that got, once a month, I have a mastermind call that's international that happens at 10:30 in the morning, and so that's the one time that I can't do my regular 11 o'clock. All right, if you guys are with me, feel free to ask a question. Usually the way that these Ask Me Anything lives go is I show up and if people have questions, I stay on as long as I need to answer the questions. And then if people are done or it's a short call, then I click off and get busy doing work. So if you've got a question, there's Jacob. If you've got a question, you're welcome to just go to unmute yourself, or you can pop it into the chat, either one.
I just wanted to say hello. I didn't leave you. I just had to do something private.
I totally get it. How are you, Kathleen?
I'm doing fine. I just came here to listen. I can't really think of something today, but I saw your email.
That's okay.
So,
You're welcome to be here. I see my friend Jacob Roy. Jacob, how are you?
I'm great. I wanted to support you today and just probably throw a question or two your way as well to help. How are you?
Awesome. I'd love that. Doing well. Good to see you.
Yeah, thanks. So I just read, I was on Paul Zalizer's podcast, and I did some research up front, and the biggest growth for entrepreneurs is 55 and over.
Ah, that's awesome.
Yeah, so, somebody out there listening, what would you say would be their most important one or two legal things to make sure that you absolutely get done right now?
Yeah, great question. So if you're 55 and older, so the first question that I always have people look at is, do you have an incorporated business, right? Have you set up a business entity that allows you to do business in a way that tells the government, your clients, the IRS, anybody that's going to have any curiosity about looking into your business, that you're set up in a way that has you protected. And especially if you're 55, you may have other assets in your life. If you're now creating your, business that you really want to be working in, you might have a 401k, you might have a house, you might have some other assets that you've already created. So more important than ever that you have an incorporated business entity from which to do business. Do not remain a sole proprietor where you're exposing anything in your life to risk that comes in the door through your business.
Yeah, great point. So related to online, what's the first priority step in legalizing your online portion of your business?
Yeah, great question. So there's 3 core activities that we do online. And I'd ask you, first of all, if you're doing all 3, great, you should be. And if you're not, why aren't you doing all 3, right? So the first activity is publishing information. So most people that go online need to set themselves up, usually a home base, which is a website. Maybe it's also attached to a membership site, depending on what they're doing or how quickly they move. But publishing information to set yourself up as the authority, right, is number 1. That's the first activity that you have to protect. And you protect that with website terms and conditions. Those are your website ground rules. They tell people what you're up to, what the rules of the game are when they're visiting your website, right? So what can you do with the information that's just posted generally on your site? What can't they do? the thing about being an online information entrepreneur is we all know how we want people to use our information. We all know the directions that we provide when we share information, but we ultimately don't get to control what somebody does with the information. And that's where risk comes in the door. So your website terms and conditions for the activity of publishing information is going to protect you by having disclaimers. It's going to have limitations of liability in there. And so that's the first one. The second one is, are you collecting information, right? So you're publishing information, you're collecting information. I'll go ahead and give you the third, selling information or selling your services, which exposes information, right? So those are the three activities. I call it the three-legged stool of being online: publishing information, collecting information, and selling information. You need legal tools in place for each of those activities. So website terms and conditions we touched on. The second one, collecting information, we need privacy policies in place. There's no business in the world right now that can be collecting any information online without a privacy policy and not be violating some laws. So if you're collecting information and data, which you should be, just do it the right way and have a privacy policy in place, which basically the role of the privacy policy is, as a business owner, you're obligated to disclose to people what information you collect, why you collect it, how you collect it, where you keep it, how you keep it safe, how they can opt out of your database, right? So it's all client facing or website visitor facing. It's all about their rights to their data. You have to make those disclosures. So that's a privacy policy. The third piece, selling information or selling services that disclose information. And in the online world, I mean, Jacob, you know, this happens a million different ways. Courses, digital downloads, digital products that are made up of a variety of things. You can sell people into live services. You can sell people into workshops, right? There's all sorts of things that you can sell. You need terms of purchase in place for those things. And terms of purchase really cover the specifics of that transaction. Just like somebody walking into a store and buying something, they leave with a receipt. Your terms of purchase have all the terms related to that transaction. It includes your refund policy. It includes protections for your intellectual property that you expose as part of whatever you've sold. So if it's a course, digital download, there's a lot of great IP in there. You want to have some language that again says, here's what you can do with this information, here's what you can't do with this information, right? So those are kind of the core tools for an online business from a legal perspective. There's best practices, there's some additional education that goes along with those. And that's why I talk a lot about my website protection package for people in the online space. If somebody is doing B2B, especially around sales, I mean, you're one of these guys, right? Sales, generating income, growing your business. You also need an earnings and income disclaimer. So that's a separate disclaimer that the FTC, which is the Federal Trade Commission, they are the consumer protection watchdog for us here in the United States. They want to see an earnings and income disclaimer pulled out and posted separately on your site, because of all of the get-rich-quick schemes that happen out there, right? There's a lot of claims about, oh, you're going to make $100,000 or make $1 million, and the FTC wants people who are really legitimate to make sure that they have proper disclaimers in place saying, this is not a business opportunity, this is not a get-rich-quick scheme, results vary. So the earnings and income disclaimer is really important for people really doing any conversations about money, about earnings, about sales, etc.
That's profound.
Yes.
It's a lot of information. I can just share, and it's not a pre-planned promotion, but I know that you've helped me, and there's no way I would, one, know what to do. I probably wouldn't take the time to find out until I got myself in a jam. But I also know in my own experience that my guess is 60%, and I think I'm being really nice, aren't doing anything.
Yeah.
Like, you don't see the disclaimer show up or they're just unaware of it. And, this is like some serious exposure that I'm hearing from you if we don't have it in place, right?
It's true. We've got, and it's really interesting because during the time of COVID, I've been watching, I'm on the email list that the FTC, you can sign up and receive updates from them, and a lot of attorneys do. And Kathleen, I see that you've raised your hand. You're welcome to type a question or I'll get to you next. And welcome, Tom. Good to see you. I see that we still have Wayne on, so I just want to acknowledge people who are here. So the FTC, Jacob, is the watchdog in this space. And, it's really interesting because in times of crisis, scams go up, right? So it's really unfortunate, but, and people being reported for things that are like mistakes in their marketing messages or outright fraudulent claims. And I think it's really easy for people, including, the ones that I serve, to think, oh, I'm not big enough. I'm not a big enough business to ever garner the kind of attention that would land me on a list like that, right? And so I've been carefully watching like who ends up on the FTC's watch list and like cease and desist list. They send out notifications on a weekly basis telling people to stop business and stop what they're doing. It's, yes, you end up with some larger companies, but most of the larger companies are not the ones actually getting in trouble because they have legal counsel. They might get in trouble for violations of some evolving privacy laws, like we've seen with Facebook, Cambridge Analytica, right? Some of those big dogs. But, and especially if there's a breach, those oftentimes are involving data breaches. The little guys are the ones that don't know what they're doing and are the ones that are getting in trouble because they are being reported to the FTC. And so it can be like Margaret in her kitchen making potions or lotions in the Midwest. I mean, this is literally one of the examples, in the midst of COVID and being shut down because she doesn't know what she's doing. And so it's, unfortunately, a lot of people think like, oh, I'm not big enough to need the legal support that we're talking about here. And what they don't realize is that they're exactly the kind of business that's poised to get in trouble because of the lack of support and the lack of knowledge. But great question.
Great points. Thank you.
Yeah, it's good to see you on here. And I love your, the statistic number 1 about the fastest growing group in the entrepreneur clan is 55 and older. That's awesome. Yeah. I love that.
There's a lot of upside to it. Besides what we could see is, impact detrimentally, but the upside is that we're a bit mellower, and so we're a bit more patient as far as seeing the results show up. And it's an interesting one, and it proves in my clientele as well. My clientele is a little bit older than it was probably 5 years ago.
Yeah. Well, and that theme around patience is huge. That's what it takes to succeed in business. People think it's like all sorts of other things. Like it's patience, it's grit, it's commitment, and it's the willingness to like keep writing it out. And so I love that. Thanks for sharing. Good to see you. And if you have any other questions, you're welcome to chime back in.
This is Kathleen, and I wanted to say that the question I had is, again, I had this. I follow several natural health doctors, providers, and I don't think that trying not to communicate, but the email company, the browsers have gotten real picky about what sites they call safe. So they want you to be HTTPS, or they even or they will they will either block you from going to a site, which has happened to me, or they would just notify you that you shouldn't do business on that site, give out information. And so when I got that yesterday, I wrote an email to the doctor and I said, you need to fix this because your site's to be HTTPS.
That's true. It's a very good point. Very good point.
And so, because, I was actually being blocked from going to some of the summits and stuff because they weren't
hosted on a secure connection.
Yeah. And So I just thought I would mention that, because
Yeah.
that actually means we got to do whoever's doing the site has to do a little more work.
Yeah, it generally, so what Kathleen is talking about for people on here, and most, a lot of people know, not everybody, right? It's the HTTPS, and the S part is the secure. It indicates that you have a website that's secure, and that can happen in a couple different ways. Most hosting providers, because of this change in the way that Google ranks sites and allows people to visit them through any links that Google sponsors or hosts on its search engine, they prioritize sites that have an S on them. So if you're behind the times and you haven't upgraded, you need to talk to your website host. And some website hosts are providing this. It's basically an SSL certificate automatically. Some don't, and you have to pay. I mean, in my experience, it's between like $70 and $100 a year for an SSL certificate to protect your site. And that indicates to people that it's a more secure site than if it doesn't have the S. And what that means is that there's less transparency when you have the S when people go to purchase from your domain or your site. So you want that level of protection. But great point. Tom Birchall, do you have a question? Or Wayne, who's been with us since the start? Do either of you have a question that I can help with?
Heather, I'm sorry. This is
Wayne.
Wayne. I've got this. This is kind of a weird or convoluted, but I thought I'd try and run this by you. My father had passed away recently, and we're looking at putting my mom into an assisted living facility. Now, one of the things that come up for communication, and they have, is like, you can get it from like Verizon, it's called a GrandPad. Now, say we buy her a GrandPad, and we have them at home. But say she wants to not give it, or let her friend use it in the facility. Mm-hmm. At that point, because I'm not even sure what their total terms of service are yet, because we haven't purchased it yet. But I'm just wondering if you're going from a private to commercialization because you're letting somebody else use it in a facility, even though you've given them permission to use it. And say several other people use it within the facility.
And give me a little bit more details what you mean about going from private use to commercialization.
Instead of it just being used for like her and our family, she has a friend at the facility and she lets them borrow it, and they communicate with their friends at home and maybe another friend there, and they give it to them, but it's all the same pad. It's all the same piece of hardware, just different people using it.
And are you asking this question based on having reviewed their terms of service or their terms of use?
I haven't seen it yet because the one piece of hardware I was looking at, it isn't even shipping until December. It's not quite a GrandPad. It actually hooks up to your TV. It's a little bit different option, but they're not even shipping until December.
Okay, well, I'm on their website here. I just thought I would look it up since I haven't looked at this before. The question, what you're talking about, really gets down to whether it violates their terms of use, right? And, without reviewing them in detail right now, generally, I mean, I'd be very surprised if letting a friend use it to also connect would somehow violate their terms of use. I'm on their site and I'm just looking really quick.
Because I did do a little research, and what I found, it kind of actually scared me, is because it's like there's supposed to be one person is supposed to be in charge, like for managing photos, and it's like there's an overseer, or you've got like God watching over who can do this and who can do that, and it's like,
well, and it could be if they're and I don't know much about the GrandPad company. It could be that they want to maintain really tight controls over usage. And especially if it's related, if it's tied in, like if internet service is provided through the device as part of the service, I could see that being a problem. So what I would say is you just want to really review, which they have right here on their websites, the terms of use regarding their service, and just read through those. They should be clear enough. I mean, terms of service are designed, or they're actually nowadays required to be written in clear English. That doesn't mean they always are. But you should try to look through and see if you see anything there. Otherwise, you could definitely have an attorney review those for you. Yeah, it looks like to answer Tom's question, I think, Tom, if I were to guess, I'm guessing that it is both a device and an internet service tied into one that's also designed to be very, very user friendly. It's for grandparents, and my suspicion is that there's a technology piece there that they've tried to simplify, that it has like a user friendly experience or something that makes it, for example, more ideal than an iPad or something else, for somebody who just wants really simple connectivity. And I don't know if that's correct.
It also has Verizon service built in too, which kind of,
Oh,
if Wi-Fi is not there, so Verizon's got their terms of fingers in that too. Which
totally.
makes me lean. I was looking at maybe just getting a laptop and putting Zoom on it, and then they could share it
Right.
out
Or
the
an
window.
iPad. Right. An
As long as
iPad is so
as long as you
inexpensive.
keep as long as you keep the meetings under 40 minutes, you can run with the free service all day long.
Totally. Yeah. You'd want to look at that carefully and compare your options. I bet that there's also some reviews online that you could look at and benefit from between like an iPad and something like this. But yeah, it's good to know what you're getting into oftentimes, especially if they're related to like a provider like Verizon, what you're getting into before you sign up for sure. And they're not always
All right.
good at disclosing that.
Yeah.
All right. Wish I could be more help, but I would just say read,
No,
read
that was
carefully
good. Thanks,
through those
Heather.
terms. Yes. I'm sorry, Wayne, to hear about the
No,
loss
that's all right. I'll go
of
back and
that.
review them some more. But I think I'll go for an independent or try and go, and that
I
way it doesn't,
My
you know.
preference is always to go and benefit from portions of the marketplace where you retain free choice around how
Yeah,
you
'cause
use it.
if I buy the laptop or the iPad and run Zoom, then her or anybody else, anybody can use it, and then it won't matter to anybody. So
Yes. Well, and even FaceTime, depending on what devices you have at home, there are some that are so easy, they're almost like impossible to screw up, right? So look for
right.
one of those. Well,
Okay.
good luck.
Thank you.
Yes. All right, Tom.
Hey, Heather, I hope you're doing well.
I am. How are you?
I'm doing fantastic. It's been heads down and just go, go, go.
Yes, good.
good.
Well, I'm so glad to hear that.
But I got a question.
Yeah.
Question round. My question is around trademarking and such. So, as you and I have launched podcasts recently, it's around names and kind of some of that
Yeah.
proprietary type of information and the trademark process.
Totally. So are you thinking about then getting a trademark registration for the name of your podcast, The Profitable Maverick?
That's right.
Okay. And are you looking at doing that in Canada, in the States, in both locations?
Tell me more.
Okay. So the quick overview, and we'll talk about copyrights and trademarks real quick, okay? Copyrights, and let's first distinguish between what they are, and for purposes of people live, but also for people that access the recording of this call, right? I want to make sure that everyone has context. The way that I describe trademark and copyright protections, if you think of your brand, your business, even your podcast as a mountain, right? The snow-capped peak at the very top, the part that's visible that everybody sees, that's what you protect with trademark registrations. That's a business name, a short name, a title, a tagline, right? So these are words or short phrases that you can protect with a trademark registration. Now, not everything is protectable, right? So what makes for a good trademark registration? What makes your brand name or your business name or and when I distinguish between brand and business name, let me tell you what I'm talking about. So my LLC, so I have the Legal Website Warrior, right? Which is an online secondary business to my traditional legal practice. My business name is not the Legal Website Warrior, and I've coached a lot of people on these calls. You can set up an LLC that's like 123 Media or whatever, right? I have lots of clients that have kind of a nondescript LLC name as their formal business registration name.
Which is DBA in the States, right?
Right. Well, that's the main name. Yes. And then you can have a DBA, a doing business as, it's also called a fictitious trade name that is something else. So my something else is the Legal Website Warrior. That's my brand name. And I've got a trademark registration around that so that nobody else can use the Legal Website Warrior. So that's what I mean. But like you can, if your business name is also the way that you get brand recognition, maybe you are seeking a trademark registration for your business name. For some people, that's not the case because they have more of a nondescript business name, but they've got a really recognizable brand name. So, what
Because
makes
your
Go
business
ahead.
name then is what?
Mine is HJP Strategies LLC.
Okay.
Okay. So, depending on how you set up your business, and people's brands also evolve, right? I've talked with people who set up their first business name as, something unrelated to their personal brand. And then now they've evolved more into, a personal brand or a slightly different space. And so sometimes it's actually really beneficial to have a fairly nondescript business entity name because you can always register a new DBA or create a new brand name or something else. So we could go way deep into those strategies, but the gist of it is that when you are choosing something to seek a registration around in the context of a trademark registration, what makes it more protectable is that it's unique, that it's not descriptive or generic. And what I mean by that is actually, we've got a great example here in Seattle. You've got Starbucks coffee company, right? Starbucks here. Nobody says Starbucks in the normal course of business unless you're referencing Starbucks, right? It's not like a word that comes from our dictionary or our normal lexicon. But Seattle's Best Coffee, that's another company based here in Seattle. That is not something that you can protect, but it is a business. They chose it, they went with it, and it's not a trademark registration that is actually protectable because any other business in Seattle that makes coffee can claim to make Seattle's Best Coffee. Those are words that come from the dictionary. You cannot remove from usage by other people, if that makes sense, right? So that's where you want to analyze, is your language or your phrase or your business name, is it descriptive? Is it generic? Are you just using words that everybody already uses? Or are you creating something that really didn't exist before? Nike. You don't say Nike unless you're referring to the company Nike, right? Now, taglines are a little bit different, right? Nike's tagline, just do it, also protected by trademark, right? So both the company name and the tagline have separate trademark registrations. And we use the words just do it. But when you say it in the context of commercial use, everybody knows who it is when you say that tagline, right? So if there's a phrase that you use so predominantly in your business, so consistently that it literally has brand association for you, and you'd be devastated if somebody else used it, it's time to think about a trademark registration around that phrase or tagline, right? So that's what I mean when I say top of the mountain, the snow-capped peak. That's what people think of when they think of your company, brand recognition. That's all protectable by trademark. Now, the rest of the mountain, that's the body of your work. That's your podcast. That's your workbooks, your worksheets. That's your articles, your email newsletters, like all of the content that you produce, all of the ways that you take your ideas and put them into tangible form. Those are the rest of the mountain. It's the body of your work, and those are protected by copyright registrations. Okay, so I just like the mountain analogy because it's really easy conceptually to think about brand recognition. What's at the top of the mountain, that's protectable by trademark registrations, and then the rest of it is the body of your work, and that's protectable by copyright registrations. Now, quick note on, because I want to talk also about this international, this international issue. Because you're based in Canada, a lot of people that jump onto my calls also are based in Canada or other places in the world, but copyrights, you don't have to register. You don't have to go seek a registration to own the work. What it means is that when you put an idea down, and let's be clear that copyrights do not protect the idea, they protect the expression of that idea, right? Jacob, good to see you. So happy to see you. Thanks so much for popping on. So copyrights protect the expression of that idea.
Say that again.
Oh, I was just saying goodbye to Jacob. He had typed into the chat, and so I was saying adios. So, but copyrights protect the expression of the idea, not the idea itself. So what this means is that you can only protect the things that you put into tangible form, like an article, like a blog post, like a video tutorial, like a podcast episode, right? You're creating something in a tangible form. The benefit of seeking a registration around those is that if you had to pursue infringement, having a formal copyright registration gives you the right to recover damages, including treble damages, which means attorney's fees. It makes your ability to enforce your intellectual property rights a lot stronger, a lot easier. So, but you don't have to. You can still put, the copyright notice when you create something, and you still have ownership over that thing. It just may be harder to receive damages, recover damages if somebody else steals it. So that's the benefit of a copyright registration. Now, with copyright registrations, when you're talking about doing international business, right? Because we have a lot of Canadians that come to the US or have audiences based in the US. Same with the UK, same with Australia, same with other places. Most, I think it's 164. There's some fairly large number of countries that have signed on to something called the Berne Convention. And the Berne Convention basically says if you have a copyright registration in your country of origin, we will honor it here in our country as well, right? So that means that you would not have to go cross border and seek copyright registrations in the US if you already have them in Canada. Now you have to play by the rules of your own registration system. So you'd have to know in Canada
to be covered.
Yeah, exactly. To be covered and have that respected in the US. But trademarks are different. Trademarks, you have to have a trademark registration in Canada if that's one of your marketplaces, and you'd also have to seek a separate trademark registration in the US to have that trademark recognized here.
So trademarks are specific to country. Copywriting is not under the Berne Convention.
Under the Berne Convention, that's right. Yep.
Okay.
Does that help?
Yeah, and then process. What's the process for?
Yeah, the process for in the States getting a trademark registration is that you've got two bases for an application. One, which is that the phrase or the name is already in use, you're already using it, or it's intend to use, right? Most people that I work with, and I generally encourage this, use it already. You want to be first in commerce because your application, one of the things that you have to say is when was the first date you used that phrase or name in commerce, right? So you want it to be early. And this is why I also encourage people not to sit on their ideas. If you have an idea, so long as you've researched it and you're aware that you're not infringing other people's rights, push it out there, get it out there because you want to have first use in commerce. So you submit an application, right? You have to indicate, is it that you're already using it or is it that you intend to use it? And if you intend to use it, you have to use it within a certain time frame. And then you generally have to submit proof of that use, right? So what are the ways that you are using this particular phrase or name or whatever in commerce? Is it on business letterhead? Is it in your email marketing? Is it online when you do online advertisements? Is it on a website that you drive traffic to? Often just publishing to a website is not enough, especially under copyright rules. You actually have to be using it in commerce, selling it, using it in the course of your trade and your business. So for trademark registrations, you want to show proof of use. Where does it exist? How have you been using it? And that's where you come up with specimens that you submit along with your application. In the United States, that entire process, because once you submit it, there can be some back and forth where they need some additional information or they do some research themselves and they have questions that they need clarified. So there can be some, things that you have to respond to from the United States Patent and Trademark Office. And this is often why people are better off having attorneys that can help guide them through that process. Sometimes they come back and they say, oh, will you waive the use of this particular word? And they'll ask for exceptions. That can sometimes land you on the supplemental registry. We have a supplemental registry and a principal registry here in the US. If you are on the principal registry with your registration, it gets affirmed, you wait you submit your application, you wait the time, and then you get an actual registration. If you're on the principal registry, you have exclusive use over that phrase or that name. If you're on the supplemental registry, you don't. By very nature of being on the supplemental registry, you're actually presumed not to have exclusive use. So there's some nuances that can come up in that process around this back and forth that happens with the USPTO.
Yeah, and just in that principal or supplemental, is that while it's being adjudicated or figured out, or is it in perpetuity? Like once it's decided, you're in one or the other? Which is it?
Once it's decided, you're in one or the other.
Okay.
Right. And so let me give you an example. I had one client that went through Trademarkia. He either tried to do it himself or he had a Trademarkia or something like that, which means that you don't have an attorney really shepherding your particular application through. You've got some admin or clerk doing the work, and then it's kind of off to the races. He ended up signing off on something as part of that application because he got a question back from the United States Patent and Trademark Office and he didn't know what it meant, and he thought, okay, this is fine, I can sign off on this, and I'm just excited to have a trademark registration. He ended up on the supplemental registry, and now he's got a worldwide brand that is literally, he's got a cult following around the world. We put like 2.8 million of advance fee publishing agreements in place for him. He wrote a book last year. He cannot get foreign trademarks. At least he's had some initial struggles getting foreign trademarks because guess what? They look back to the United States system first and they go, oh, you're on the supplemental registry. You're not on the principal registry. So you must not have exclusive use over this particular phrase.
So the supplemental list, describe that a little more, because is it useless?
I know, it's weird. It's in my mind, and I could be wrong on this, but in my mind, it's another way for our government to collect fees, right? It's another way for them to acknowledge that you're using something in business without actually giving you the full rights to use it in business exclusively, right? So what you find, and what can happen with some of the marks that end up on the supplemental registry is that if they continue to be used for 5 years and they are used exclusively, they can acquire that first in line status. I'm not sure what the conversion mechanism is, and I don't know that it actually converts to the principal registry. It might, but a lot of people end up on, and I've had this happen when I use the term legal coach in my business. I had this woman show up and claim that she had exclusive use over the word legal coach, which she doesn't. This is a term that's been around since the 90s.
Sure, it's pretty nondescript.
It's pretty nondescript, like health coach, business, it was, anyways. It was surprising to say the least that she thought she had exclusive use over this term, and basically I told her to go fly a kite and not to contact me again. And she hasn't, but she's on the supplemental registry, right? And so what that means is that for whatever reason, they acknowledged her use of it, but she doesn't have exclusive rights. And there's a lot of marks on the supplemental registry that are that way, which also means if you receive a cease and desist from somebody, because I get this question as well. Some people will launch something into the marketplace and then they have somebody running around telling them to stop using it or they can't be doing such and such. Like, you need to get some legal help in a hurry so that you don't give up rights, because if somebody's on the supplemental registry, they don't have exclusive rights to their mark. And so that does not mean, and a lot of people will just cave. They'll just sign over their rights or change their label or change their marketing material so that they're not infringing. And it's a more complex scenario than that. You need to look into the details of what the actual registration allows them to do, what registry are they on. And so, people just get really nervous anytime attorneys are involved and they're on the end of a, any kind of a cease and desist. But I'm just saying that there are different levels, and it's, it's not always to your advantage to be placed on the supplemental registry, which is also why, some advanced coaching from an attorney who can look at what exists in the marketplace, look at other registrations. Sometimes it's a small tweak to the language or maybe to the classifications, like the classes that you're trying to get registered in, if you've got any flexibility, would be the difference between obtaining a mark versus not being able to obtain a mark.
Is the supplemental primary similar in Canada as the States?
I don't know. I'm not sure if Canada. Let me just do a quick search. Is Canada? And supplemental registry for trademarks. Let me see if I can get an answer to that question. I'm not sure. I'd have to do a little bit of reading on that because I don't know if these are coming up in regards to the U.S. system. Yeah. See, many people are surprised to discover that United States Trademark Office has two types of registers on which a trademark may be registered. The principal and the supplemental register. Yeah. So there, if you do some Googling on this, you can find out some of the benefits, right? So limitations of supplemental register. There's no presumption of ownership, exclusive rights of use, or validity, right? So it's, I know and this is why it's so disappointing for people to go through this process and then learn. This woman that sent me the cease and desist, presumably she did not, even though she was an attorney, she did not know that being on the supplemental registry the register did not give her exclusive use, right? So
she may have been banging the drum and hoping that you didn't know the difference.
That's right. And this is why they're also, one of the things I try to teach people is that be aware that there are bullies in the marketplace who will end up on the supplemental register and then try to use that as a strong arm tool to get you to stop using something. Doesn't mean you have to stop.
Okay.
Yep.
Pricing, ballpark kind of...
Yeah, so I have seen when I have reached out to other attorneys in the past, because probably last year alone, I'm guessing I sent 30 to 40 trademark registrations, referred them to other attorneys. General pricing that is pretty typical in the marketplace, I would say, would be between, $2,000. Some attorneys charge as high as $3,400 or $4,000, $3,500 or $4,000 per registration. Largely depends on what the scope of services includes along with that. But it's, when you're talking about that top level brand protection, right, it is an investment because it gives you exclusive rights, assuming it goes well and you get on the principal registry, gives you exclusive rights to your business name, to your, whatever it is that you're trying to obtain a trademark around. Now, because obviously being on my list, I just launched this and I'm testing. I want to run 10, 15, 20 people through the process. And so I've really done some savings pricing initially. So my launch pricing is $9.97 per trademark. That's single class trademark. So if you have multiple classes, there's going to be some additional fees added on because the trademark office, first of all, the filing fees are separate anyways, but the trademark office does filings per class. So the filing fee for the United States Patent and Trademark Office is $275 per class. And so it just means that you have more work. And so $9.97 would be a single class trademark, and then an additional fee for my services go up from there depending on how many classes somebody wants to register in. But there's a gal that I talked with and she's probably got 3 classes, but still based on my initial pricing, that's $1,500 to get that trademark application submitted, handle what are going to be probably pretty typical questions in the response process. Sometimes the trademark office requests information that's really exorbitant to collect, or they'll submit back I was talking with a gal who said the trademark office sent her back like 50 different documents, I think probably referencing other trademark registrations in the marketplace and asking for, how you distinguish from other people's use. So sometimes certain responses can fall outside of what is considered normal. And that means that the price would go up a little bit just based on time, because it takes a lot more time to filter through a request like that from the trademark office than a clarification around, your use in business or an update to your file in another way.
Yeah. Okay.
Okay.
This is Kathleen.
Hi,
Is anyone else waiting to talk?
I don't think so. Just Tom. Unless, Tom, did you have any other questions related to that?
No, don't think so. I'll get in
Okay.
touch with you more if there is. So appreciate
Okay,
that. Thank you.
You're welcome. Good to see you, Tom. Great
I
questions.
had a couple of related issues. Well, right now I'm taking a class from Lisa Sesovich,
Mhm.
which she's about trying to figure out your tagline and stuff like that.
Mhm.
And I have a question about Facebook,
Mhm.
but first I had another comment related to what you said there. Now I follow a certain person who has been in business for 20 years with an expression that, anyways, they feel that this other YouTuber has infringed on the copyright or whatever, even though she's not using the exact phrase,
Mhm.
but she's kind of giving the same kind of information.
Mhm.
But they said that she's kind of been ignoring them. And so I was wondering about that. I mean, it's almost the same phrase, but one word is different.
Yeah. So that's a great question, Kathleen. And in the world of trademarks, so this is why it's so important to get trademark registrations, is that especially if you're in a similar category or class, which is how our trademark registration system is run, right? So like, for example, if you had, and I'm just picking a very generic phrase like live your best life, and that was on clothing, that's very different than that being a phrase used by a life coach or whatever, right? Two totally different classes. Somebody's not going to be confused about whether or not they're buying clothing or life coaching services, right? So you can have the same phrase or the same mark exist in different places, but totally different uses. Now, what would be confusing is if you had two people in the coaching industry using the same phrase or substantially the same phrase. And this is why trademark registrations, the whole system is actually based around the concept that we need to protect consumers. So the question to ask around any infringement scenario is there the likelihood of confusion, or has actual confusion in the marketplace been created by this secondary use? Now, it's a little bit like, if you go to lunch and you want to buy a Pepsi and you get a Coke, right? Something happened there where you did not get what you intended to order, and they're not the same product. The trademark registration system is really designed to protect people so that they buy what they think they're buying instead of a related service or product that, looks like option one. So from that standpoint, even though it's not exactly the same phrase, if it has the potential to cause confusion in the marketplace where somebody thinks they're buying from, Coach One, or it causes brand confusion, there absolutely can be infringement there. Now, if it's a word or a phrase, that's protectable by trademark. If it's longer content, because there's a lot of people that duplicate and copy, other content, somebody's 5-step system, or, whatever. There's a million ways that content gets expressed
Well, they're
in the
both
world.
on YouTube, and they do, like budget time, towards women. It's mostly towards women, and housekeeping and stuff like that kind of stuff. But the lady that started out, she started out with a cookbook 20 years ago. In fact, if 9/11 hadn't happened on that day, she would have had an interview on Oprah.
Oh,
I mean, that's
wow.
the only
Yeah.
had her brand.
Yeah.
But I don't know how the thing got set up. So I was just kind of curious, and I don't want to say it because that's not nice to say someone's company.
That's right. I appreciate you being cautious. The reality is we have multiple strategies available to protect our content, right? And this is why, and ideally, if you're creating content or you have created content, especially if it's part of your core offerings, so, you know, whether it's a cookbook, whether it's, you know, a whole system that you've developed for marketing, whether like whatever it is that's kind of your special sauce and your core, a core part of what you deliver. Because people will come and ask, well, like, what do I copyright? Everything? Like, we all probably create a ton of content. And like Tom, for example, creating a podcast, you can also get copyright registrations that protect a sequential work. So you don't need to protect, you know, every single thing individually. You can protect the series. Or photographers, for example, if they've created a series that are designed to go together and it's created over time, you know, you can protect a series of photographs or images or artwork created within a 1-year calendar period, and have that be protected under a single copyright. So there are ways to protect your work that actually don't make it outrageous to do. But, you know, I always say start with your core work, like whatever it is that really forms the basis of what you're doing and the work that you're putting out in the world, and protect that. Because there are people out there that will duplicate it. There are people out there that will rip it off and do stupid things with it. And we're getting better. I think people are getting smarter about this stuff, and that they're starting to understand that infringement is something that can be pursued. But to the extent you have registrations, copyright registrations that are done within 3 months of creating the work, you have much better protection from the standpoint of being able to pursue infringers and recover damages.
The other thing that's kind of interesting in this is that I don't think she was on YouTube. I think the other lady was, the second lady was on YouTube before the original person was, but they were on the internet since like the beginning.
Yeah. Well,
but they were YouTube specifically because they just kind of started doing it, you know, when YouTube got more.
Totally. We don't all use the same platforms. Yeah, somebody could publish information on platform X and somebody else could totally rip it off and republish it or do their own version of it on platform Y. But it's really about, you know, are you using it in commerce? You know, there are different rules as far as how you protect trademarks versus copyrights. But one of the things that I definitely recommend, especially for digital content, so I'm talking about blog posts, articles, images, or like information graphics that you're publishing online, put either your watermark if you're a creator or your copyright notice. And your copyright notice should be, you know, C in a circle, the year that the work was created, and then your name as the copyright holder. So copyright, when you create a work of, you know, tangible form, copyright rests with the individual. You can transfer those rights to a business, like you can make an assignment or, you know, sell those rights to a business or whatever, but copyrights rest originally with the individual. So it'd be copyright 2020, you know, Heather Pierce Campbell or Tom Birchall or whatever. Put those notices on the content that you create, and don't just rely. Some people will put that at the bottom of their website and think that that covers all the content that they create through their website. Not true. I mean, from the standpoint of like people data scraping and removing a copyright notice or removing a watermark, you want to have your copyright notice like right at the bottom of the work, or if it's an image, like embedded right over it. You want it close enough, in close proximity, that if somebody steals your content digitally and scrapes it off, because you have access to certain kinds of damages that way, even without a copyright registration. So make sure that you, I just invite people, like, liberally use your copyright notice, because it also acts as a flag. Like, hey, I created this, it's my content, and people have to be more thoughtful about whether or not they're going to remove those kinds of notices if they're just copying and pasting somebody else's work. So,
A question about timing.
mhm.
I had heard in the back, this might be about inventing, about the idea that you should be keeping something in writing when you start working on like an idea or something to show. I mean, a lot of people don't do this, and then
Mhm.
maybe someone else starts thinking along the same line, or they see your stuff and they try to steal it, but you don't have it written down.
Yeah.
Is that true anymore?
Well, I mean, I think, it never hurts to document your own work, and depending on whether it's a trade secret or whatever you're doing, you obviously want to keep it safe. Excuse me, I feel like I'm going to sneeze. Around trademark registrations, like I talked about before, the timing of the idea itself doesn't matter. It's the use in commerce that puts you first in line.
Okay.
So you've got to use your name or tagline or phrase in commerce. Tom, the trademark registration isn't subject to that 3-month rule. That's copyrights. So copyright is about getting a registration in relatively close proximity to when you create the content, so that those things in time are somewhat related, and it also gives you the presumption, right, legal presumption, that the content is yours. Now for me, for example, like, I've got a website with lots of content and I haven't copyrighted it. But I'm getting ready. I'm in the middle right now of a website redesign. Like, I'll be launching a new website in, I don't know, as soon as I can finish some of the copy. You can sure as bet that I'm going to be seeking registrations around some of the core content of my new website, and doing it within that 3-month timeline to make sure that I've registered a lot of the content that will live on my site for a while. And
So are
because,
you changing your name online?
what was that?
Are you going to change your name online?
No,
Or you just
not changing my name. I already have a registration around my brand name, right? That's protected by trademarks. I've already got a trademark registration for my brand. But I'm talking about like web pages, videos, things that actually make up the body of my work and that will be published and live and accessible on my website. I'm going to be much more mindful about copywriting, getting a copyright registration within that appropriate time frame. And you can also like upgrade certain like works. Like, if you've got something that existed in a previous form, right, you can update it, modify it, repurpose it, get a copyright registration around that.
Will the
So
3-month be reset when you launch that new site? Like, is that part of the purpose of doing the new site, is to have a point in history?
Yeah, the purpose of doing the new site is really just because it's time for my brand to grow, and it's time for me to redo some of the language and the specific audience that I'm talking to. So it's bigger purpose than that. But in line with that,
Right.
I'm also going to be very, very careful about protecting my content more proactively.
Yeah. And what's the process for that? You talked through trademark. My understanding is that copywriting was simply, mail it to yourself, just get it in circulation. But you're talking about a more specific process.
And that's kind of an old wives' tale, that whole deal about mailing it to yourself. Yeah. So publishing it, because the issue with copyrights is, has it been published? And this is what I was saying about even just putting it online doesn't actually constitute published. You need to be using it like more proactively, like selling it. It needs to be content that's in a course, like it's in the marketplace. You're using it and selling it, and people are paying for it, and that's what makes something protectable by copyright. So even just printing it on a document doesn't mean that it's published. It needs to be circulating. It needs to be pushed out there.
And then is there a formal process for copywriting as well?
Yeah, so it's similar to trademarks where you submit an application. The filing fee is much less. Like I think the starting filing fee in the US for a copyright registration is $45, right? So if you had a series of videos, you could probably copyright the whole series. If you had, just a collection of videos that are not part of a series, even if it's a couple $100 to get that registered, it's worth it if it's really part of your core work. Or a workbook, right? It's one copyright registration. I mean, for one of my courses that I put on a few months ago, like I literally created 100-page workbook in 2 days, right? So there's a lot of content that we create that if it's going to be the basis for some of your core work or offerings, choose the really key parts of it and get copyright registrations around that, because it's not cost prohibitive. And you basically go online, you can submit the application, you can either provide a digital version of it, or you can mail and print and mail in a hard copy version, or like a hard copy recording, because you can do audio tracks, you can do videos, you can do music. There's all sorts of things that you can get a copyright registration around. But you can either upload it and send it in digitally or hard copy. And obviously the hard copy takes a little bit more time to process. But that process, the trademark process from start to finish is usually 9 to 12 to 18 months, right? It's not probably going to be anything less than 9 or 12 months, but it generally is going to be wrapped up by 15 or 18 months. The copyright registration period is a little bit shorter than that. Usually those are completed, I want to say, within 8 or 10 months. Maybe less sometimes, but it's a much smaller fee. Once you get it submitted, it's, just a waiting process for them to process it, get it logged, get it, taken care of on their end.
Quick one.
So,
What's that tool that is for seeing what amount of information is duplicate? So if I've written an article, I want to search online to see if somebody's scraped it and is using it.
Totally. So you are thinking of Copyscape. I use their services to track my website. They've got different levels. If you just go to copyscape.com, they've got different levels of tracking basically plagiarism online. So they've got Copy Sentry, which is the one that I use, where you get automatic plagiarism alerts. And then they give you a little banner that you can embed on your website to notify people that you're protected by Copy Sentry, meaning that you've got eyeballs on your site. And I think that that's quite helpful as well.
Thank you.
Yeah, you're welcome. And it's really relatively inexpensive. Like I want to say that I have like 5 or 7 of my web pages tracked, like my main website pages, through Copy Sentry, and it's like $3 a month.
Yeah. Okay.
Yeah, really inexpensive. So totally worth it, especially if you're concerned with, people duplicating your content.
well, what I've been doing for myself is, because I haven't been really getting into, like I go on Zooms like this, but I haven't really gotten into ever recording myself, on my own end. So I have a YouTube identification, but I don't actually have a picture attached to it or anything, because well, I was really shocked. I kind of don't want to put it out unless I'm going to actually need to put it out. You know what I mean? Because I don't want people to steal my photographs.
Totally.
About that kind of stuff. But I was thinking about Facebook. Now, what I do is I only have my personal page, but I like to put articles or deals, different things that I might put something about your site on it because I think it might be a good resource to someone else, and I thought I might want to do try to make a business page or something kind of based on that.
Yeah, absolutely. Obviously you can go in and go through, there's some, I'm sure basic tutorials about how to set up a business page through Facebook. Facebook terms of use generally require that if you're doing stuff related to business, that you do it through a business page. They don't like to see people's personal pages being used for business. And I've had friends that have been shut down on Facebook because of that. So you want to be really careful that you are going along with their terms of use. I think probably what you're also talking about here, and and I understand like just wanting to share things related to business or that you find helpful, but if you're doing that at all through affiliate links, you're also going to want to have
Hello.
Oh, hello. So I was just talking about sharing through a business page. You want to be really careful that you are complying with Facebook terms of use. They generally don't like to see individual accounts being used for business. And so a business page is a good idea if you're going to actually do business on Facebook.
Yeah, I kind of thought that, but I was
Yeah.
watching something on a summit where they talked about some of the ways that you could use your personal page. Anyway, I'm not saying that I would do it just because they recommend, but I know it's time for you to go. We've been here an hour.
No, thank you. I appreciate that. And Wayne, thanks for showing up today. Good luck to you. Thank you, Kathleen. Great to see you. You guys take care and have a really good week. Okay.
All right.
All right.
Bye.
Thank you.
Bye. Thank you. Be safe.